Hi, I'm former bar grader and law professor Jay Bijlani. If you're preparing for the bar exam, I know that a huge source of anxiety for you is how to memorize the substantive law. As soon as some other bar review company ships to you that tall stack of substantive law books, I know what you're thinking. What the? Are you kidding me? How is it at all possible that the state bar expects me to memorize the mountain of information that's in those books? Here's a big secret. They don't. The bar examiner's expectations do not rely on as much memorization as you think. Instead, when it comes to the substantive law, they want to see law knowledge from you. Law knowledge is your ability to show that you understand the rules of a specific subject. I get into quite a bit of that understanding of the rules in the video titled, How Do I Pass the Bar Exam? Watch that immediately after you watch this, and you'll see what I mean. So, if law knowledge, showing true rule comprehension, is the end game, then how does memorization fit in? Am I saying that memorization is not important at all? No. Of course your memorization of your rules is important to MBE and essay questions. After all, on the MBE, you have a lot of rules to think about, and on the essay, the bar grader wants to see rule statements in your essay answer. The question then becomes, how much rule or substantive law do you need to memorize for the bar exam to showcase your understanding of the law? Well, first, do not be fooled by what's out there. The bar preparation industry is completely unregulated. That tall stack of books, those seemingly endless lectures, and those workshops on substantive law that other bar prep courses provide is what I call bells and whistles. They are redundant and contain unnecessary extra information. They give the illusion of value. The truth is only 15 to 20% of that content, depending on the company, is even useful to you. Save the rest for a bonfire. It's cathartic. The simple fact is that you are not a robot. There is no way you'll be able to memorize that much information. And guess what? Your bar essay grader doesn't expect you to be able to recite all of that. Again, law knowledge is about showing your understanding of the details. So what do you need to do about getting the law into a format that is condensed enough for you to be able to memorize it while still accurately stating the rules on essays and accurately thinking of them on the MBE? Well, you have two options. Option one is you find a reputable bar exam prep course or tutoring program that will include a magical substantive law book that ticks both boxes, condensed for memorization, as well as contain the accurate buzzwords for the essays and for the MBE. If you enroll in an Esquired program, you will get this. I personally developed this substantive law book of outlines for each subject. It is currently available only through the multifaceted programming offered by Esquired Bar Exam Prep and is not sold separately. Now, option two is to create your own substantive law outline for each subject that is succinct for memorization and contains the rules that can be accurately presented to the bar grader. Mind you, this requires a substantial amount of time and energy. A first-time bar taker will often try to create their own outlines from scratch using the heaps of outlines and lectures and workshops they have accumulated from other bar prep companies. This can be both very time-consuming and frustrating. I feel for you. Unfortunately, I took this uphill path myself when I took the bar so many years ago. It takes precious time away from engaging in copious amounts of practice to develop the skills that the state bar really values, which are law application and law expression, as I've said before. However, if you do have the time, patience, and skill to condense or distill the information into outlines that you can memorize and that include the buzzwords, let me show you how. First, I would take a set of rules that needs to be condensed. Look, I'm not going to single out a specific bar review course by going through their stack of books, lectures, and workshops for this demonstration. That's not who I am. Instead, I will use some publicly available law that is actually tested on, for example, the California bar exam. Let's look within the subject of professional responsibility at the model ABA rules and the California rules of professional conduct that focus on a lawyer's duty of fairness to the opposing party and counsel. If you're wondering, I'm looking at Rule 3.4 of both the ABA model rules and the California rules. Let's take a look at them. By the way, if you find this video helpful already, please show your support by liking it and subscribing to the Esquired Bar channel. Here is the ABA model rule on fairness to the adversary. Here is the analogous California rule. California bar exam takers are expected to know both. The good news is that they are similar. However, where they are different, a California bar examinee needs to articulate the difference to the bar grader. Let's dig in quickly to make an outline you can memorize more easily and that would enable you to demonstrate your law knowledge. When creating your own outline, you'd want to consider two things. First, consider what are the keywords or buzzwords you need to extract from the rule so that they stand out prominently in your mind as well as on your paper for the bar grader. I'll use my trusty highlighter to do that. Second, ask yourself, how frequently tested is this rule anyway? Is this a rule that comes up a lot on essays? If it is, then it is more important that you memorize the actual buzzwords that you extract. If it does not, then many other bar takers will have trouble remembering it, and you'll have more latitude to rely on your common sense understanding of the rule rather than your memory of the specific wording when articulating the rule on the exam. Where available, the sample answers published by the bar illustrate this point, the importance of recalling the actual language of a specific rule to the quality of the answer. Okay, now let's create an outline of this one section, which would of course appear in our professional responsibility outline. Looking at the ABA rule first, we begin to read ABA Model Rule 3.4, Fairness to Opposing Party and Counsel. A lawyer shall not unlawfully obstruct, okay, so we're going to highlight obstruct because that is a key word here for this subsection, another party's access to evidence or unlawfully alter, destroy, or conceal, right? There's a bunch of words there that maybe I can more summarily memorize given how infrequently this rule does get tested and yet would still show my understanding of it. So how about I stick with one of them, the most encompassing one, destroy. Okay, destroy or conceal a document or other material having potential evidentiary value. So we're talking about something that comes into evidence, documentary evidence. A lawyer shall not counsel or assist another person to do any such act. Okay, so I'm not going to add that because obviously, if the lawyers themselves cannot do this act of obstruction, then surely enough, I know I'll remember that a lawyer can't counsel or assist someone in doing the same thing. All right, so where does that leave us? Now, let's make an outline of this. So taking that first section over here that we see from the ABA, I created a draft outline. And as you can clearly see, and this would eventually appear in my professional responsibility outline, we can we will see that it has a very clear outline format. Now, you see it says fairness to opposing party and counsel, Roman numeral 1. Then the ABA rule, a lawyer must not, which is what I got from that first part over here. This subsection is all about obstruction. So I'm going to label that obstruct, and I'm just going to insert the keywords into my outline. Obstruct or destroy documentary evidence. Isn't that something that we see? Obstruct or destroy documentary evidence. Now that makes it a lot easier to memorize. Okay, let's repeat that with the next section. A lawyer shall not falsify evidence. So we know to, of course, highlight that. Counsel or assist a witness to testify falsely or offer an inducement to a witness that is prohibited by law. Well, that's a heck a lot of a lot of law that we already know. So obviously, if they can't falsify the evidence, they can't counsel or assist someone else to do so. So the keywords that we get here are simply falsify evidence. All right. So into my draft outline, the premise of that subsection is falsification. So falsify, a lawyer must not falsify, meaning falsify evidence. Those are the keywords that I put down. Next, we see knowingly disobey an obligation under the rules of a tribunal, except for an open refusal based on an assertion that no valid obligation exists. Well, looking at this, I'm not really going to highlight this, and I'm not going to want to put that into my outline. Why is that? Because what we're doing is we're again looking, of course, for buzzwords, but really how important is it to our memorization? Would I not know or remember at least that you can't disobey an obligation uh, under the rule of a court? Of course I will. So this isn't something I want to use my brain cells to try to memorize. So I know that there are going to be a lot more specific areas that will be encompassed by this rule. Okay, so I'm just going to skip that one, knowing that it's very rarely tested, if not tested at all, and can be encompassed by other rules that are more specific. Okay, subsection D. In pre-trial procedure, make a frivolous discovery request or fail to make reasonably diligent effort to comply with a legally proper discovery request by an opposing party. Okay, that's chock full of keywords right there. Let's see how I was able to simplify that. So basically, when we're talking about pretrial procedure, we're effectively discussing discovery. So I'm putting that as a rule of discovery. Make frivolous discovery requests, and we already know that because they put the keyword in there, or fail to comply with proper discovery request by opposing party. So you see that over there as well. You see, this is how you create an outline that can be memorized more easily, yet say the same thing. All right, next one. In trial, okay, so now this subsection focuses on the trial itself. Allude to any matter that the lawyer does not reasonably believe is relevant or that will not be supported by admissible evidence, assert personal knowledge of facts in issue, except when testifying as a witness, or state a personal opinion as to the justness of a cause, the credibility of a witness, the culpability of a civil litigant, or the guilt or innocence of an accused. Whoa, okay. So basically, this is about the lawyer inserting themselves personally into the evidence, right? And the statement that I know will best encapsulate the rest of the entirety of the statement would be right over here. State a personal opinion. That's just probably all I would really want to remember and easily apply to a variety of facts that encompass all these situations over here that are enumerated. So I would then take that subsection and put it in a more digestible format. So a lawyer must not, and this relates to a lawyer's opinion, in trial, state personal opinion on evidence. That's it. You see that? That makes it so much easier to memorize. Next, and finally, we're subsection F, request a person other than a client. Okay, so this is about third parties to refrain from voluntarily giving relevant information to another party unless, okay, so there's a general rule and then there are going to be some exceptions here. The person is a relative or an employee or other agent of a client. Okay, so an employee or other agent of a client. And the lawyer reasonably believes that the person's interests will not be adversely affected by refraining from giving such information. Okay, so there's a reasonable belief that the the third person's interests will not be adversely affected. Okay, all right, so let's see how that plays out on my outline. Over here, this is about giving information. So a lawyer must not give. What does that mean? Must not request third party to not give relevant information to another party. And there's the exception, which is a sub A under number 5, specific to just that sub provision, exception that the third party is a relative or agent of the client and lawyer reasonably believes the third party's interest will not be adversely affected. Ta-da! So you see where I got that from the highlighted portion over here. Feel free to pause the video and compare what I wrote over here, or sorry, what I highlighted over here and captured over here in this part over here. Okay, now we move on to the California rule. So this will be quite similar in the way that we approach it. So the California Rule 3.4, fairness to the opposing party and counsel. All right, so we're in the same spot over here. And we're going to start creating an outline of what that provision says. That's over here. A lawyer shall not A, unlawfully obstruct, here we go again, this sounds very similar to the ABA model rule, another party's access to evidence, including a witness, or unlawfully alter, destroy, or conceal a document, other material having potential evidentiary value. A lawyer shall not counsel or assist another person to do any such act. Extremely similar to the ABA rule. And as you can see, I'm taking the highlighted portion, those keywords that I found, and just simply putting them into my outline here. In California, a lawyer must not, and the first provision relates to obstruction, as it did with the ABA rule, obstruct documentary or testimonial evidence. Okay, then we go on to the next. This one says, suppress. B, a lawyer shall not be suppressed. Now, this is new. We didn't see this in the ABA model rule. Suppress any evidence that the lawyer or the lawyer's client has a legal obligation to reveal or to produce. Okay, so we see that those are the key words in this rule that is specific to California. And so we see under California, a lawyer must not suppress either. What does that mean? Suppress evidence that the lawyer is obligated to reveal. See how much more simply that is stated than what the actual rule is, yet it says the same thing. Third, the lawyer shall not falsify evidence. Okay, remember this from the ABA model rule as well. Counsel or assist a witness to testify falsely or offer an inducement to a witness that is prohibited by law. Well, as we said earlier, we're just going to keep the falsify evidence piece because, of course, if the lawyer can't do it, they can't counsel someone else to do the same thing. So those are the keywords we need, falsify evidence. And we see that over here. California lawyer must not falsify evidence. Okay, D, directly or indirectly, so no matter what, pay, offer to pay, or acquiesce in the payment of compensation to a witness contingent upon the content of the witness's testimony or the outcome of the case. So you can't pay a witness for their testimony. Now, except, here's an exception, where prohibited by law, a lawyer may advance, guarantee, or acquiesce in the payment of, okay, so you can pay for the expenses reasonably incurred by a witness in attending or testifying, reasonable compensation of a witness for loss of time in attending or testifying, or a reasonable fee for the professional service of an expert witness. Okay, so we see this is unique to California that doesn't exist under the ABA model rule. So Lawyer must not pay a witness for testimony. That was the general rule. Don't pay your witnesses, except here are multiple exceptions. Reasonable expenses incurred by a witness for attending, reasonable compensation to witness for loss of time in attending, and or reasonable expert witness fee. And that's voila, what we see over here in more words. Okay, then we get down to advise or directly or indirectly cause a person to secrete himself or herself or to leave the jurisdiction of a tribunal for the purpose of making that person unavailable as a witness therein. Secrete. Okay, I don't know if that's really a key word here. I think the whole idea is about the making that person unavailable as a witness. We do not want to do that. Don't make someone unavailable as a witness. So don't cause a witness to become unavailable. Okay. Now, the next one, F, a lawyer must not knowingly disobey an obligation under the rules of a tribunal except for an open refusal based on an assertion that no valid obligation exists. That's the same rule that we decided not to put in from the ABA rule because that's kind of obvious. We all know that. No need to worry about that. There are other rules that will encompass it. So I didn't include it over here. And then finally, in trial, assert personal knowledge of the facts and issue. Here we go again. This whole thing is about opinion, except where testifying as a witness or state a personal opinion as to the guilt or innocence of an accused. That's more simple than what the ABA says, but it doesn't seem to include any fewer circumstances than the ABA, really. So for the purposes of the bar exam, I think I can just simply say lawyer must not state an opinion in trial, right, on the evidence. And there you see it right there. And so now what we see is that I have condensed 526 words of awkwardly presented law. I ran the word count from both of these provisions to simply 153 words. It's now much easier to memorize. Now I can format this even better to be able to memorize this. So let's see how this ended up in my substantive law book, the one that I held up for you earlier. Here's the page in professional responsibility. Basically, what I had done was to make it a bit more memorizable for myself. So you see that I broke it out. I noticed that there was a rule here relating to discovery, which is different from everything else, which relates to evidence, which presumably relates to trial. And I just separated that one out under ABA for when it comes to discovery. The lawyer must not make frivolous discovery request or fail to comply with proper discovery request by opposing party. So that rule has been taken care of, the one that I put over here. And then as far as evidence goes, and the fairness to opposing party and counsel, a lawyer must not. And from there, I listed out all the common ones between the ABA and California, and that would be the obstruction, the falsification, the opinion, and listed them out for easy memorization. And then separately had the ABA and California distinctions so that I can easily say, I know what is common to both, and then say in ABA, well, there's this specific rule over here. And then in California, there's another specific rule with its exceptions. And that clustering, I can reorganize my outline to cluster information for efficiency and avoid redundancy and create a fun mnemonic, which I did over here. All in the name of accurate and easier memorization. Okay, you see how I cluster the pieces of information so that I can better digest it. And my mnemonic is G, sup, fool. And so I said, read that as G, what's up, fool. And what does that mean? It means that I have the ABA G SUP for sup, the California piece, and then foo is the FOO. That is common to both. It makes me giggle a little bit. It makes me be able to memorize that more easily. It makes it definitely more memorable. Okay, now you ask yourself, can I memorize this more easily than the original volumes of law? Yes, the brevity and logical organization make it easy. I even have a mnemonic in there, as I just said. Does it effectively say the same thing as the original set of rules that I had? Yes, of course it does. It has all the important keywords, the buzzwords. It shows that I understand the law. This is only one small area of law that is testable on the bar exam. Imagine having to do this for every doctrine in professional responsibility and every doctrine in every subject tested on the bar exam. Wow, you would need a ton of time. Think about all those bar review companies that flood you with law in their volumes of books, lectures, and workshops. Instead of distilling the information for you like you need them to, you're forced to do it yourself using their information dump, which often present the rules differently. You find yourself asking, should I memorize the rules the way the lecturer presented it, or as the author of one of the books did? It's insane. That thing with mini in its name is not mini enough. No wonder I hear so many of you, after having taken another provider's course, complaining that you were overwhelmed and were able to keep up with only a fraction of what they expected in their schedule. This is not how you want to use up your time for bar preparation when you only have a couple of months to prepare and have a lot of practice to do. So now you know how to create your own substantive law in a condensed format that you can memorize with the right buzzwords. However, you will want that extra lead time and patience in advance of your full-scale bar study time to get it done right. If you do not have the time and energy, you can still hit the ground running with condensed substantive law that is easy to understand and memorize. I have it right here, available with my programming. Each outline is on average 15 pages long. Can you believe it? Well, now you can, because all the rules have been constructed in the same way I just showed you. It is all the bar law you're going to need on both essays and MBEs. It is painstakingly constructed for efficient memorization in that the rules are logically organized and succinct. It is directly to the point. It is truly no nonsense, designed for the bar grader's eyes, free of bells and whistles, so that you can memorize using the buzzwords and spend more time on what's really important, practicing to improve your law application and law expression skills. In whatever way you get your substantive law, either one where your bar prep company provides it to you or one that you have developed yourself, it should be like this: your one source of law that serves as your Bible for any bar essay or MBE question. That's right, just one source, and it better be good. One that is logically organized, succinct, and directly memorizable. It should have buzzwords, examples, and mnemonics for easy comprehension, memorization, and presentation with the eyes of the bar grader in mind. If you've enjoyed this video, please don't forget to like it and subscribe to the Esquired Bar channel. In the meantime, study smart and best wishes on the bar exam.